Welcome to the Deep Dive, the show where we take complex topics, dig into the source material, and unpack the essential insights for you.
And today we're diving into, well, a really fascinating and important area, UK patent law.
Yeah, it's something that affects innovation hugely. Imagine, you've had this brilliant idea, maybe a new gadget, a process, something you've worked on for ages,
Mhm.
and you think, okay, how do I stop someone just, copying it, taking all that work?
Exactly. And that's fundamentally what patent law is trying to address. It's the system designed to protect those inventions.
So it gives inventors exclusive rights for a while?
Precisely. For a limited time, yes.
Hmm.
It's a complex area, no doubt, but absolutely vital, especially in today's economy, which relies so much on innovation.
And this deep dive, it's based on some comprehensive academic materials, right? Provided specifically for educational purposes.
That's right. These are materials designed to give a really solid grounding in the subject. Our aim here is to walk you through the fundamentals, pull out the key points from these sources.
Think of it as your detailed guide, helping you get your head around how inventions are legally protected here in the UK.
We'll cover quite a bit. We'll look at the history. Where did this all come from? We'll
Sure.
touch on the reasons, the justifications for having patents at all. Then the big one, the modern law,
Hmm.
the Patents Act, 1977.
Okay.
We'll briefly outline how you actually get a patent, the procedure, just for context, and then spend a good chunk of time on the really crucial concepts, the things that come up again and again in patent cases, the core issues.
Sounds good. So let's start at the beginning then, the history. You said it goes back surprisingly far.
It really does. You have to go back centuries. Even the word patent gives us a clue. It comes from the Latin, literae patentes,
Literae patentes, meaning,
open letters. Basically, back in the Middle Ages, the crown, the king or queen, used these official documents, these open letters, sealed with the Great Seal, to grant certain rights,
like permissions.
permissions, privileges, and importantly for us, monopolies, the exclusive right to do something.
So the monarch could just say, okay, only you can make or sell, I don't know, wool.
Essentially, yes. And these grants were, well, a bit of a mixed bag. Sometimes they were used to encourage genuinely new things, bringing in new technologies, skilled workers from abroad, that kind of thing, things we might see as beneficial.
Right. Promoting industry.
But very often, maybe even more often, they were just granted to raise money for the crown or as favors to courtiers. Monopolies on completely ordinary things, playing cards, salt, soap.
Playing cards, so not necessarily about innovation at all, just control.
Exactly. Power, privilege, revenue. That's a really important part of the history to grasp. And this wasn't just an English thing either. The sources suggest the Tudors were probably influenced by what was happening in Europe. They mention the Statute of Venice from 1474 as an early example over there.
Okay, so it was common practice, but surely granting monopolies on everyday stuff caused issues.
Oh, big time. Especially under Elizabeth I, there was overuse, granting monopolies left, right, and center. And this led to real public anger and, crucially, legal challenges. People started taking these grants to court.
This is where the famous case of monopolies comes in, Darcy v. Allen.
That's the one, 1602. It involved a monopoly on playing cards, exactly the kind of thing we were talking about.
And what happened?
The court basically said, look, this kind of broad monopoly, restricting trade in ordinary goods, it's generally against the common law, against the public interest. It was a major pushback.
So the courts were saying monopolies bad.
That was the general vibe emerging, yes. But it wasn't quite that simple. There's another case mentioned, the cloth workers of Ipswich case from 1615.
Okay, what was different there?
Well, in that case, the court upheld the grant. But the key difference was that this particular monopoly was tied to bringing a genuinely new technology or skill into the country, something seen as beneficial.
Ah, so a monopoly on playing cards, bad. A monopoly for introducing a new weaving technique, maybe okay.
You've got it. That's the crucial distinction the courts were starting to make. It's this idea that maybe a temporary exclusive right could be justified if it was for something new and beneficial, even though monopolies in general were frowned upon.
And this legal tension, these cases, led to actual legislation.
Directly. Parliament was getting pretty fed up with the Crown's power to grant monopolies. This all culminated in the Statute of Monopolies in 1623, a landmark piece of law.
What did it do? Did it ban monopolies?
Well, Section 1 was pretty blunt. It declared all monopolies, past and future, basically altogether contrary to the laws of this realm and void. So it confirmed the general rule. Monopolies are illegal.
Okay, baseline. No monopolies.
Right. But then came Section 6, and this is the absolute key for patent law. Section 6 carved out a specific exception.
An exception for what?
It allowed grants for a limited term, usually 14 years back then, concerning any manner of new manufacture within this realm to the true and first inventor.
Any manner of new manufacture to the true and first inventor. That sounds incredibly familiar. That's basically a patent, isn't it?
It's the direct ancestor, yes. And what's truly amazing, and the sources really stress this, is that for over 350 years, until the 1977 Act, that Section 6 was pretty much the only substantive law defining what could be patented in the UK. Everything else developed through judges interpreting those few words from 1623.
Wow. And is it true that Section 6 is technically still on the statute books today?
It is. Which really underlines a fundamental point.
Hmm.
Our modern patent system is built on an exception to the centuries-old principle that monopolies are generally bad for trade and the public. This tension is hardwired into the system.
How did things change with, say, the Industrial Revolution? Lots of new inventions then.
Absolutely. The 19th century saw a huge surge in invention and therefore in the use of the patent system. There were various acts passed, but they mostly focused on the process, how you applied, how patents were managed. They tinkered with the procedure.
But not the core idea of what a patent was.
Not really, no. That still rested on the interpretation of new manufacture from Section 6.
Was everyone happy with the system during this industrial boom?
Not at all. The sources mention there was actually a really fierce debate about whether patents should exist at all. Free trade proponents argued they actually held back innovation, created barriers, stopped people improving things.
Sounds like debates we still have today about open source software or access to medicines.
Completely. The core arguments haven't changed that much. But despite that debate, the patent system survived, and its basic legal foundation remained largely the same until the massive changes in 1977.
So understanding this history, this inherent tension, is important context for the modern law.
It's crucial. It helps you understand why the law is structured the way it is, why courts might be careful about the scope of patents. It's not just a random set of rules. It's a system born from this long historical balancing act between encouraging invention and keeping trade free.
That makes a lot of sense. Okay, let's briefly touch on the justifications for having patents in the first place. The sources link this back to broader IP theory.
Right. They mention that the general justifications for intellectual property were covered elsewhere. For patents specifically, the detailed arguments, why do we grant these temporary monopolies, what's the public benefit, are found in core texts, people like Cornish, Bentley, and Sherman. This specific material doesn't list all the theories.
But it flags that thinking about the justification is important.
Very much so. And it points out that these justifications aren't just academic. They actually pop up in court cases sometimes.
Judges talk about why we have patents.
They do. The sources say justifications are sometimes rehearsed in case law. They give examples like Lord Oliver and Rajasahi KKK's patent, or the Court of Appeal in Dranes Anstalt v. Hayek, and also in Eli Lilly and Company v. Human Genome Sciences, Inc. Judges might refer to the policy goals when interpreting the law.
So it's useful to keep those underlying reasons in mind when looking at the specifics.
Definitely. The sources really emphasize this. It helps you ask critical questions. Does the law on, say, patentability or infringement actually achieve the goals the justifications claim? Does it really incentivize invention and disclosure effectively? It's a framework for analysis.
Right, not just learning the rules, but thinking about whether they work as intended. Okay, let's get to the main event. The Patents Act, 1977. You called it revolutionary. What changed?
It was a complete reset of the substantive law. Instead of relying on interpretations of that 1623 phrase, new manufacture, the 1977 Act introduced detailed statutory rules about what is patentable, what isn't, infringement, and so on. And the main reason for this massive change wasn't purely domestic.
Yeah.
It was international.
International treaties.
Yes. The UK needed to bring its law into line with international agreements it had signed up to. Two main ones influenced the Act. First, there's the Patent Cooperation Treaty, the PCT, from 1970.
PCT, what does that do?
It's mainly procedural. It allows an inventor to file one international application as a first step towards seeking patents in many different countries. It streamlines the initial filing and search process.
So it makes applying internationally a bit easier.
Kind of, yeah. It standardizes the first phase. The sources mention its useful background. You'll see references to PCT applications, but the nuts and bolts of the PCT procedure aren't examinable under this syllabus.
Okay, good to know. What was the other more significant treaty?
That was the European Patent Convention, the EPC, from 1973. This is the big one that really shaped the substance of the 1977 Act. The UK ratified the EPC, and the act was largely designed to implement its requirements for harmonized patent law across member states.
And the EPC has been updated since then?
Yes, there was a major revision, EPC 2000, which came into force in late 2007. The UK's Patents Act 2004 made amendments to keep UK law aligned with that.
Now, the sources stress something important here. EPC sounds European, but it's not an EU thing.
Absolutely vital point. The EPC is not an EU treaty. It's run by the European Patent Organization in Munich, which is linked to the Council of Europe in Strasbourg. Its membership is wider than the EU. Very important distinction.
Okay, EPC, separate from the EU. Got it. What does the EPC system actually provide?
It created the European Patent Office, the EPO. The EPO offers a single, centralized procedure for applying for, searching, and examining patent applications for any of the EPC member states the applicant designates.
So one application to the EPO can cover multiple European countries.
Yes,
And if the EPO grants it, you get one single European patent.
that's another key clarification from the sources. No, not usually. A successful EPO application doesn't result in one unitary right, leaving aside the newer, separate unitary patent system for now. Instead, what you get is effectively a bundle of parallel national patents. Yeah. Once the EPO grants the patent, it essentially springs into life as a separate national patent in each of the countries you designated in your application. So you might get a UK patent, a German patent, a French patent, etc., all arising from that single EPO grant.
So it avoids having to go through separate examination in each country, but the end result is national patents.
Exactly. And because they become national patents, if you want to sue someone for infringing your EPO-granted UK patent, you do that in the UK courts, applying UK law, which of course is the 1977 Act, designed to align with the EPC.
Okay, that makes sense. The sources call the 1977 Act a hybrid creature. Why hybrid? What are the different parts?
Well, it pulled together elements from different places. A large chunk of the substantive law, particularly what counts as patentable and what's excluded from being patented, came directly from the EPC.
Right.
Then, the statutory definition of what constitutes infringement was based on the wording of another treaty, the Community Patent Convention, though that one was never fully ratified.
So EPC for patentability, CPC for infringement. What else? Any purely UK bits?
Yes. The Act also included provisions that were entirely domestic creations, not driven by treaties. Key examples are the rules about who owns inventions made by employees, and the special scheme for compensating employing inventors if their invention is outstandingly successful.
So a real mix of international obligations and domestic policy. This international influence must affect how UK courts read the Act.
Hugely. And it's mandated by the Act itself. Section 130, subsection 7, shell at 1307, is incredibly important here.
What does S1307 say?
It basically says that the key parts of the Act dealing with patentability, sections 1 to 6, infringement, section 60, and grounds for revoking a patent, section 72, must be interpreted in a way that gives them the same effect as the corresponding provisions of the relevant international conventions, mainly the EPC, have in other member states.
So UK judges can't just interpret the Act in isolation. They have to look at how the EPC is interpreted elsewhere in Europe.
Exactly. Section 137 forces them to aim for consistency. The sources point out that this means UK courts must consider decisions from courts in other EPC countries.
Which one specifically?
They are particularly directed to consider decisions of the EPO's own boards of appeal, especially on patentability issues. Cases like Merrill Dow v. Norton and Bristol-Myers Squibb v. Baker Norton Pharmaceuticals are cited as examples where the UK courts explicitly acknowledge this duty.
Any other foreign quotes mentioned?
Interestingly, yes. The sources mention that senior judges, particularly Lord Hoffman, in cases like Kieran Amgen v. Hostas Marion Roussel and Connor MedSystems v. Angiotech Pharmaceuticals, have also suggested that UK courts should take notice of how German courts interpret patent claims. Germany has a very well-developed patent system and jurisprudence.
Wow. So UK patent law really is interwoven with European law and practice through the EPC and this interpretation rule.
Absolutely. Understanding this hybrid nature and the mandatory European dimension under S11307 is fundamental. It affects almost everything else.
Okay, that's a great overview of the modern legal framework. Now, before we get into the really deep concepts, the sources include an outline of the procedure for getting a UK patent at the UK Intellectual Property Office, the UKIPO. You said this is mainly for background.
Exactly. The sources are clear. This procedural stuff isn't really examinable as such. It's provided mainly so you understand the jargon terms like filing date, priority date claims, specification, sufficiency when you encounter them in judgments.
Got it. So just a quick walkthrough. The sources list 5 main stages.
Yes, filing the application, then publication, then search and preliminary examination, then substantive examination, and finally, grant.
Stage 1. Filing. Who can file?
Section 7 says pretty much anyone can apply. But the patent itself can only be granted to the actual inventor or someone entitled through the inventor, like their employer or someone they've assigned the rights to. The UKIPO can sort out disputes about entitlement.
What has to be in the application?
Section 14.2 lists the requirements. The key documents the sources highlight are the specification and the claims.
Specification and claims. What's a specification?
That's the main descriptive part of the patent. It has to describe the invention, usually with drawings, and it also includes the claims at the end. It's written for the skilled addressee, that hypothetical technical person we'll talk more about soon.
And there's a critical requirement for that description called sufficiency.
Yes, under Section 14.3. This is hugely important. The description must disclose the invention clearly and completely enough for a person skilled in the art, the skilled addressee, again, to actually perform the invention without needing undue burden, like excessive experimentation.
So the instructions have to be good enough for a skilled person to make it or do it.
Essentially, yes. And if it's not sufficient, that's a major problem. Lack of sufficiency is a ground for revoking a granted patent under Section 72(1)(c). The sources give some really helpful case examples showing what insufficient means in practice.
Okay, let's hear a few.
Well, there's Monsanto v. Merck. This involved a drug patent claiming anti-inflammatory effects without certain side effects. The patent failed on sufficiency because while the description told you how to make the chemical compounds, it didn't reliably ensure that all the compounds made would actually lack those side effects as claimed. The teaching didn't match the breadth of the claim's promise.
Ah, so it wasn't just about making the thing, but making the thing with the claimed properties.
Exactly. Then there's Kimberly-Clark v. Procter & Gamble about disposable nappies. That one failed because the test described in the patent for measuring absorbency gave conflicting results. The skilled person couldn't reliably tell if a nappy met the standard or not.
Inconsistent instructions. Got it.
Another one. Novartis v. Johnson & Johnson Medical about contact lenses. Insufficient because achieving the whole combination of claimed features, comfort, health benefits, and specific physical properties, would require the skilled person to do way too much extra research and experimentation beyond what the patent taught. Undue burden.
So too much guesswork needed.
Right. But Connor Med Systems v. Angiotech clarified something else. For sufficiency, you need to explain how to perform the invention and show that it works. You don't necessarily need to explain why it works. The underlying scientific mechanism isn't always required.
Okay, the how and the that, but not always the why.
Yeah.
That's useful. The sources also mentioned some big Supreme Court cases on sufficiency recently.
Yes, very important ones. Warner Lambert v. Actavis dealt with second medical use patents using a known drug for a new purpose. The court said for these claims to be sufficient, the patent has to make it plausible that the drug actually works for that new use. You can't just speculatively claim a new use without some basis in the patent. In that case, involving pregabalin for pain, the plausibility standard wasn't met for the full range of pain claimed.
So for repurposing drugs, you need some plausible evidence in the patent itself.
Yes. And then there's Regeneron v. Kymab. This involved genetically engineered mice. The Supreme Court took quite a strict line. The patent claimed a broad range of mice, but the teaching only enabled the skilled person to make some types within that range, not the whole range. Because the disclosure didn't enable the full scope of the claim, it was insufficient.
So the teaching has to match the claim's breadth. If you claim wide, you have to teach wide.
That's the principle from Regeneron. And finally, the sources mentioned Fibrogen v. Akebia, where the Court of Appeal usefully categorized different types of insufficiency. Classical insufficiency, unclear instructions. Biogen insufficiency, claimed too broad for the teaching, like in Regeneron. And uncertainty.
That classification sounds helpful for sorting out sufficiency arguments. Okay, that's the specification and sufficiency. What about the other key part, the claims?
Ah, the claims, Section 14.5. These are arguably the most important part of the patent document. They define, in precise words, the matter for which protection is sought. They set the legal boundaries of the monopoly.
So they state exactly what the invention is that's being protected.
Yes. They need to be clear, concise, supported by the description, and usually relate to a single invention or inventive concept. Section 60 makes clear that claims can cover a product, a thing, a chemical, or a process, a method of doing something. Often patents claim both.
And the priority date, the sources flag that as vital too.
Absolutely critical. Under Section 15, the date you file your application at the UK IPO is normally your priority date. However, under Section 5, if you previously filed an application for the same invention in another country that's part of the Paris Convention, which is most countries, you can claim the filing date of that earlier foreign application as your priority date for the UK application, provided you file in the UK within 12 months.
So you can effectively backdate your UK application's start date to your first filing elsewhere.
Yes, that's the benefit of convention priority. And it's crucial because, as Section 15 says, the validity of your patent, whether it was new, whether it was inventive, is judged based on the state of knowledge at the priority date. Everything hinges on that date.
Wow, okay. Filing, specification, sufficiency, claims defining the scope, priority date setting the timeline. What's next? Stage 2, publication.
About 18 months after the priority date, the application is published in the official patents journal. This makes the invention public. And crucially, under Section 69, once the patent is eventually granted, the owner can potentially claim damages for infringement that happened after publication but before grant.
So publication puts potential infringers on notice.
Yes, though publication can be stopped if there are national security concerns, Sections 22, 23. Also, while the UK doesn't have a formal opposition system like the EPO before grant, third parties can file observations under Section 21, pointing out relevant prior art to the examiner.
Okay. Stages 3 and 4 are search and examination.
Right. The UKPO examiner searches for prior art, Section 17, to check novelty in an inventive step, does a preliminary check of formalities, and then performs a substantive examination, Section 18, to see if the application meets all the legal requirements, novelty, inventive step, industrial applicability, not excluded subject matter.
And if it passes all that, stage 5, grant.
If it meets the requirements and the fees are paid, the patent is granted, Section 18.4. This has to happen within about 4.5 years of the priority date. The grant is published, Section 24.
And how long does the patent last?
Maximum of 20 years from the filing date, not priority date, under Section 25. But importantly, you have to pay annual renewal fees from the end of the 4th year onwards to keep it in force. These fees go up over time, miss a payment, and the patent lapses.
Can you change the application or the patent after filing, amend it?
Yes, amendments are possible both during examination, Sections 17, 18, 19, and after grant, Sections 27, 73, 75. You might want to narrow the claims, for example, or correct an error.
Are there limits on amendments?
Big limits. Section 76 is key here. You cannot amend the description to add technical information that wasn't in the application as originally filed. No added matter.
Yeah.
And you cannot amend the claims so that they extend the scope of protection offered by the patent as granted.
So you can only clarify or narrow the protection, never broaden it after the fact.
That's the rule. Attempting to improperly broaden the scope through amendment is actually a ground for revoking the patent entirely. Section 71D and E. And whether an amendment improperly adds matter or broadens the scope is judged, yet again, through the eyes of the skilled addressee. Cases like reflexible directional indicators and Bonzel v. Intervention look at this.
Okay, so even though the procedure details aren't the main focus, understanding these elements, claims, sufficiency, priority, amendment rules really helps make sense of the cases and the documents involved.
Definitely provides the essential scaffolding.
Right. Now, let's get into the real heart of it, the key issues and concepts that dominate patent litigation, the stuff courts grapple with constantly.
These are the absurd building blocks for analyzing patent disputes, and the first one is figuring out the inventive concept.
The inventive concept, what exactly is that?
It's the court trying to understand, well, what is this patent really about? What was the inventor's actual contribution? What problem were they trying to solve, and what was their clever new solution? That core idea is the inventive concept.
Do judges call it other things?
Sometimes. The sources mention terms like the epitome of the invention, used in the Dyson v. Hoover vacuum cleaner case, or the essence, mentioned in cases like Unilever v. Shafaro or H. Lundbeck v. Generics. They're all trying to get at the same thing, the core contribution.
And how do they identify it?
Primarily by reading the patent claims, but reading them in the context of the description and any drawings. The claims set the legal boundary, but the description tells the story and explains the invention.
And you mentioned the problem the inventor was tackling. Is that important here?
Critically important. Lord Hoffman emphasized this in the major case Biogen v. Medeva. You must consider the technical problem the patentee was trying to overcome when identifying the inventive concept. Understanding the problem illuminates the nature of the solution.
The problem and solution approach.
Exactly. The Wheatley v. DrillSafe case is given as an example of a court applying this method.
Okay, so identifying the inventive concept is about understanding the core contribution. Does that directly determine infringement? Does an infringer have to take the inventive concept?
It's a bit more nuanced than that. The Supreme Court looked at this in Schutz v. Viret. They basically said that while identifying the inventive concept helps understand the patent, infringement is ultimately decided by whether the defendant's product or process falls within the literal scope of the claims, as properly interpreted. Taking the essence isn't enough if you're outside the claim language.
Right, so inventive concept helps understand the patent, but infringement analysis sticks strictly to the claims. Got it.
Okay, next key concept. And this one is possibly the most pervasive concept in all of patent law. The skilled addressee.
The skilled addressee, we bumped into them a few times already. Who is this person? Are they real?
No, absolutely not real. That's the first thing to understand. They are a judicial construct, a complete legal fiction. The courts invented this hypothetical person to provide an objective standard for assessing patents. The Lilly-Icos v. Pfizer case makes this clear.
A fictional person used as a benchmark. For what?
For almost everything important. Their understanding, their knowledge, their skills are the standard used to judge. How to interpret the claims. What would they understand the words to mean? Whether an invention is novel. Could they have made the invention based on what was already public? Whether an invention involves an inventive step is not obvious. Would it have been obvious to them? Whether the description has sufficiency. Is it clear and complete enough for them to perform the invention? Whether an amendment is permissible. Would they see it as adding new matter or broadening the claims, even whether an invention has industrial application? Could they see a practical use for it, as discussed in Eli Lilly v. Human Genome Sciences?
Wow. So this one hypothetical person's viewpoint is the key to validity, scope, infringement. Everything. What are they like? What skills and knowledge do they have?
Well, their technical background is tailored to the fields of the invention. So if it's a mechanical invention, they're like a competent but unimaginative engineer, Dyson v. Hoover. If it's cutting-edge biotech, they might be pictured as a team of skilled postdocs, read Genentech's patent. For IT, maybe someone with relevant qualifications and industry experience, research in motion v. Impro licensing.
So their skill level matches the technology.
Yes, but it's their mental characteristics that are really specific and, frankly, a bit strange. The description in Lilly-Icos v. Pfizer is classic. They are imagined to know absolutely everything published or publicly used in their field worldwide before the priority date, understand all relevant languages, be very good at spotting the obvious implications of prior art. They never miss the obvious. But this is crucial. They have no inventiveness whatsoever. They never stumble on the inventive step. They can follow instructions, combine known things in obvious ways, but cannot create anything truly new. They have no personal biases or preferences. They don't think outside the box or laterally. They stick to conventional technical wisdom.
Never miss the obvious, never stumble on the inventive. That really captures their non-inventive nature. Lord Reed called it having no spark of inventiveness back in Technograph v. Mills and Rockley.
Exactly. But they're not totally passive. They're assumed to be interested in their field, willing to make routine improvements, windsurfing v. Tabor Marine. They'll try experiments if they seem technically sensible, even if not commercially guaranteed, Helen v. Probantia. And in complex fields, they have the necessary time and equipment, Genentech again.
Have judges described them in other ways?
Oh yes, more colorfully in recent times. Determined but prosaic, Konig and Phillips v. Prinko. And famously, Jacob L.J. in Rockwater v. Technip were called the skilled person a nerd. Very boring, but importantly, not a complete android.
Not a complete android. So some basic reasoning ability, perhaps, not just blindly following rules.
Yes, they apply their technical knowledge rationally within the known framework. They even possess the standard prejudices or assumptions common in their field, like the vacuum cleaner industry's historical bias against bagless cleaners mentioned in Dyson.
Can this skilled person be a team?
Yes, absolutely, especially in complex fields where different expertise is needed. The sources mention Valenci v. British Radio Corporation and the Genenet case, again, as examples where the skill addressee was considered a team. Or they might notionally consult other specialists, like in Vericor v. Vetafarm.
It seems the court's trying to make the person fit the technical reality of the field.
They do, but there's a constant warning. Don't make them too skilled. They're meant to be the average, competent person in the field, not a star inventor or someone with the deep insight of an expert witness in court.
Was there a suggestion their characteristics might vary slightly depending on the issue, like obviousness versus sufficiency?
Yes, the Court of Appeal in Schlumberger v. Electromagnetic Geoservices floated that idea, suggesting that for truly pioneering inventions, the skilled person's mindset might be viewed differently when assessing obviousness, based on knowledge before the patent, versus sufficiency, where the patent itself might teach them something new.
And for obviousness specifically, there's a structured approach involving the problem.
Yes. Following cases like Illumina v. MGI Tech and Alcon v. Activis, the approach often starts by identifying the problem the invention solved. That helps define the relevant technical field, which in turn helps define who the relevant skilled person or team actually is for assessing obviousness.
Okay, so the skilled addressee, a crucial, fictional, objective benchmark. An average technician for the field with very specific, non-inventive, but knowledgeable characteristics used to judge almost every aspect of the patent.
That's a perfect summary. And this skilled addressee comes equipped with something called common general knowledge.
Common general knowledge, or CGK, what is that?
This is the basic background technical information that the skilled addressee is assumed to already know, to have in their head at the priority date. The keywords are common and general. It's the stuff that's widely known and accepted as standard in that field.
So the foundational knowledge, not specialist or obscure stuff.
Exactly. The classic definition from General Tire v. Firestone describes it as what's in standard textbooks, what's learned through routine work in the industry, the stuff people in the field take for granted. Very importantly, the sources stress CGK does not normally include the contents of specific prior patents. Those are treated as separate prior art documents to be compared against, not assumed background knowledge.
Okay, so CGK is the technical toolkit, distinct from specific prior art documents like patents.
Yes. It's the technical background, Rajab case,
What?
the good basis for further action, Wheatley case, the good background technical knowledge, Rockwater.
Is it limited geographically?
It can be worldwide for very international fields like biotech, Genentech, but might be more local for other trades.
And again, courts are careful not to assume too much.
Yes, it has to be genuinely common and general for the average skilled person, and readily accessible to them. Beloit Technologies v. Volmet. Generics v. Warner Lambert is cited as another application example.
So CGK is the assumed technical backdrop for the skilled addressee. Got it. That leads us to the final key issue, the role of the patent claims themselves.
Yes, we've mentioned them a lot, but their central role can't be overstated. Their primary function, as the sources state clearly, is to demarcate the scope of the monopoly. They draw the line in the sand. They are the legal definition of the protected territory.
Why is that definition so critical?
Two main reasons that drive almost all patent litigation. First, the claims are compared with the prior art, everything known before the priority date, to determine if the patent is valid. Is what's claimed actually new and inventive? Second, the claims are compared with the defendant's product or process to determine infringement. Does what the defendant is doing fall inside the boundaries set by the claims?
So the claims are the benchmark for both validity and infringement.
Absolutely. Section 125 of the Act says the protection is determined by the claims, interpreted according to Article 69 of the EPC and its protocol. Section 131 defines the invention as what's specified in the claims. The message is clear. The claims are the invention for legal purposes. They define everything.
And the interpretation of the claims has to be consistent. You read them the same way, whether you're looking at validity or infringement.
Yes, that's a fundamental principle. You can't twist the meaning one way to make the patent valid over prior art and then twist it another way to catch an infringer. The meaning must be consistent.
How are they interpreted then? Is it just literal dictionary meaning?
No, not literal. The approach is called purposive construction. You read the claims through the eyes of the skilled addressee, trying to understand what the patentee intended the scope to be based on the language used in the context of the whole patent document and the common general knowledge.
And Lord Hoffman's question from Kieran Amgen captures this.
Perfectly. He said the question is, what would a person skilled in the art have understood the patentee to have used the language of the claim to mean? It focuses on the skilled person's understanding of the patentee's intended meaning.
So understanding the purpose of the language from the perspective of that average technical person.
Precisely. It's an objective assessment of what the claim means to its intended audience.
Okay, so the claims are paramount. They define the monopoly. They're judged against prior art for validity and against the defendant's actions for infringement. They're interpreted purposively through the eyes of the skilled addressee, using that Karen Amgen question.
You've got it. That's the central role of the claims.
Right. Well, we have covered a huge amount today. We went right back to the historical roots, the open letters, the statute of monopolies in 1623, and their crucial exception in Section 6, setting up the core tension.
Hmm.
We touched on the justifications for patents and how they surface in court. Then the modern law, the 1977 Act, its hybrid nature, the massive influence of the EPC, and that vital interpretation rule in Section 137.
We also walk through the basic UKIPO procedure filing, publication, examination, grants, just to understand the context in terms like specification, sufficiency, priority date, and amendment rules.
And then the really core concepts for litigation. Identifying the inventive concept, understanding the all-important, slightly weird, skilled addressee and their common general knowledge, and finally, appreciating the absolute centrality of the patent claims in defining the monopoly, interpreted purposively.
It's a lot, but these concepts, skilled addressee, CGK, claims, sufficiency, inventive concept, they really are the foundation. They'll come up again and again as you look into patentability criteria, ownership issues like employee inventions, or the details of infringement.
It really shows how the law tries to apply consistent principles built on that historical context to the complexities of modern invention. Grasping these fundamentals is definitely key.
And maybe a final thought to leave you with, focusing on that skilled addressee. It's quite something, isn't it? The validity and scope of a potentially multi-million-pound patent monopoly ultimately turns on a court, deciding what a purely fictional, determined but prosaic, non-inventive technical person would have understood certain words to mean, often many years in the past. How predictable, or perhaps how uncertain, does that make the whole system in practice?
That's a great point. It really highlights the challenge of applying these objective legal standards based on hypothetical constructs to messy real-world technology and disputes. Definitely something to ponder.
We hope this deep dive has provided a solid and useful foundation for your understanding of UK patent law. These educational materials are designed to support your learning.
Keep digging into these fascinating topics. Thanks for joining us for this deep dive.